Which matter you want to withdraw? Your name? Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal.
Of the lack of the project affected countries,
We'll have it after vacation. Item number 22 to be discussed after the vacation. In the meantime, a report has been filed which will be brought on record by the registrar.
By the additional affidavit of bringing on record the compensation amount, the calculation of the compensation amount.
29 now. The learning counsel for the KAC submits an affidavit has been filed in the matter. The same be brought on record. List the matter immediately after the vacations. The data. Yes.
I did mention item number 16 of the
Item number? Item number?
51.
Yes. The request of the learned counsel for the petitioner matter stands adjourned to be listed after the petition. To be listed again on 18th of December. Interim order passed earlier shall continue till then. Yes, ma'am.
Item number
11 and 12. Okay. Mr. Eltonic, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant both the petitions. Accordingly, the petition, accordingly, both the petitions stands closed on withdrawal. Interim order, if any, stands vacated.
number 20 with the content of the other time. All the
After the vacation.
okay.
Yes. Item number 5. Let us take it when the matter is there. We'll adjourn it, but let us first take it.
Item 40.
Yes.
Is the party mediation is not, and then enter into compromise with the issue settled on.
You have informed the other side? Yes. What do you have to say? The request of the learned counsel for the petitioner matter stands adjourned to be listed after the vacations.
Item 4, my lord, become instruction. But 3 points come by the if you are some hearing, so I pray for listening this matter after vacation. 3.
Which one? Item number 3.
3. And
Item 4 is infructuous.
4 infructuous.
What is item 3?
Item 3, my lord, petitioner was the chairman. This term is expired now. My lord, the secretary of the cooperative society, my lord, finally he has been removed. Earlier we were.
We'll take it up. Let us see when the matter is reached.
I think to make item number 13. Also, actually, the economic benefit.
At the request of the learned counsel for the petitioner matter stands adjourned after the vacations. I would say
Additional activity.
Yes, we have filed an affidavit.
Yes, yes,
I have directed the registry to bring on record the same. No, is there any stay? Is there any stay operating? Is there stay operating against you? We'll have it after the vacations. We'll fix a date. The date of the delivery. Yes.
At number one. Final report was.
Yes, madam.
Yeah.
Certified copy from where? Understood. From where? Who is going to certify? Who is going to certify? Who is going to certify?
From the court, my love.
Ms. Udas, appearing on behalf of the respondent, submits the certified copy of the final report in respect of Sripsagar PSF FR number 439/2019 have been applied for, but the same have not been received, for which seeks for an accommodation. Which the matter again on 20/11/2023. In the meantime, the respondent shall ensure that the certified copy is produced on the next meeting.
Item number two, permission.
Yes,
My lord, during this case, for execution of land, compensation of amount 24 lakh and all was paid to us. The petition. Now, however, my lord, thereafter, after disbursement of that amount, the authority issued notice to us that it will refund 12 lakhs and all from the said amount itself. Because that amount is entitlement to decimal number 6. Now, whatever number decimal number 6 is served, he did not declare that to the law. And our contention is this matter. Actually, he is entitled to compensation of land impairment. One cannot be in that. And if that amount is divided, calculated, she is entitled to 3,04,080 rupees. But the authority should know it, that we have to refund your funds. That is the, yes. And the authorities, it's given affidavit matter. First affidavit, then hereafter second affidavit on the direction of the body. And in that affidavit also they indicate that decimal number 6 is entitled to 1 kata 15 decimal.
so the order should be limited to that only.
Yes. Because my lord, another thing is this one, she is not turned up. What is her case? We should come before the court and say. After notice also, she is not coming. The lordship will get from the report that notice was served.
Where is the affidavit filed by the second affidavit?
Second affidavit, it was filed on 23/12/2024. There are two. Which is going to along with reputed further by virtue of purchase in the effect of the sales of Eden Road under the science. Again, it is seen from the copy of non-money that as per order dated 11/2/99, the circulator as the revenue circle then later in 115 lakhs was related in the name of city collector. The principle of that will be private estimate. We are ready to refund that amount. 3,04,000.
Madam,
My lord,
what is your stand? Hmm?
That affidavit was filed by your lordships directly. In compliance with honorable court order dated 25/8/2021. That your lordship may look into the order dated 25/8/2021.
This was done under what provision? Huh? 1894, if there is a dispute as regards the possession, as regards the ownership, or as regards apportionment, what do? See section 30 and 31. This is a case of apportionment. What do?
When the amount of completion has been settled under section 11, if any dispute arises as to apportionment of the same or any part thereof, or as to the person to whom the same or any part thereof is paid, the collector may refer such dispute to the section of the court.
And then 31
Then
to
31, payment of compensation
31
or
to
deposit of the same in court. In court. On making an award under section 11, the collector shall tender payment of the compensation awarded by him to the person interested entitled thereto according to the award, and shall pay to them unless prevented by someone or more of the contingencies mentioned in the next subsection. If they shall not consent to receive it, or if there is no person competent to alienate the land, or if there is any dispute as to the title to receive the compensation or as to the apportionment of the collector shall deposit the amount of compensation in the court to which a reference under section 80 will be submitted.
so the reference can be either made by them under section 18, or you can make it
Yes.
in view of section 30. So why you are not doing that? If you have any dispute, why should this court entertain all these things?
But the amount is already really being given. Then now there is a direction to refund. That is agreed.
Because there is a difficulty without the respondent number 6 being represented. It becomes difficult. Let's see why the respondent number 6 is not represented.
Order dated 25/8/2021, already that 12 lakhs have been disbursed.
Why the respondent number 6 is not appearing?
Yes, sir. Already money has been received by 135,000.
Who?
That respondent number 6, madam. Your lordship would be.
No, have you refunded the amount?
No, madam, I have not refunded.
Then how did she get that
Your
12
lordship would be pleased to see on record 25/8/2021.
lakh?
This recorded that from the bonds of papers. We will say everything.
No, the service upon the respondent number 6, is it complete?
This from
How do you say so? There is no order passed by this court.
record,
What records?
official.
Office notes only shows that ID card has not been received.
That's happening to the complaint.
Here it says, can you look here? Neither ID card nor unserved notice has been received in respect of respondent number 6 till date. Then service is not complete. And because the respondent number 6,
In that case, for the fresh notices. Fresh notices.
you take fresh steps against that, because if you want this court, otherwise you refund the amount, let them refer it to the district judge who can decide. Why should this court decide this as to how on one hand, your stand is the right of the respondent number 6 is limited to 1 kata 15 lectures.
Yes.
And their stand is, as per the impugn order, is 1 bigger 1 kata 15 lectures.
That was your.
So the question as to how much it is, the affidavit cannot be made unless we hear the respondent number 6. The record does not show that the service upon the respondent number 6 is complete. Though in the order dated 19/7/2021, a presumption has been drawn by this court taking into account that any decision made in the instant petition would impact the right of the respondent number 6 No, it's okay. This court directs the petitioner to take fresh steps upon the respondent number 6 by way of registered post with AD. The petitioner is also, where does the respondent number 6 stay? Nearby. The petitioner is further directed to take steps upon the respondent number 6 by way of the state and file an affidavit of service on or before the next stage. List the matter again on 8th of November, on 22nd of November 2023. Trustee, noted through the registry of the court.
Number 3 and 4.
Yes. Item number 4 is 7520.
My lord.
And item number 4, learned counsel appearing on behalf of the petitioner submits that a writ petition we have become infructuous, for which the petitioner would not like to press the same. Accordingly, the writ petition stands closed on withdrawal. Okay, what is item number 3?
I can give it. The order number 6, my lord,
Hmm.
who was the private secretary appointed by the society in question.
Hmm.
and petitioner is the chairman, my lord.
Hmm,
Now no longer.
yes. Then,
When the respondent number 6, my lord,
hmm,
he expressed his inability in writing to carry out the functions. And also found to be detrimental to the whole file. In two deliberation on 9/6/15 by authorizing the assistant secretary to leave the amendments. That was my lord,
now you have challenged some orders here.
some order.
What are these orders?
Order is my lord page 70. 77 passed by divisional registered cooperative societies, my lord.
Hmm.
But what I want my lord submitting was the nonsense. So ultimately, this honorable court, my lord, was pleased to state the improved order that we have put to silence. Thereafter, respondent number 6, my lord, preferred appeal method. The appeal was also dismissed, upholding the stay order by the honorable single person. And that appeal.
No,
my lord,
but tell me, Mr. Counsel, what right does the petitioner have now?
Correct, my lord. Now it is no longer.
Huh?
So from that point of view, but the resolution, my lord.
Huh?
But the resolution which was taken, it was adopted, my lord, in the capacity of the director of board, my lord.
Understood, but what right of the petitioner as of now is there? He's no longer the chairman.
He is no longer the chairman.
Is he is he one of the directors?
He was the chairman of, no, now nothing.
What do you mean?
But pursuant to the resolution, my lord, the assistant secretary is still functioning, my lord.
Huh?
The assistant secretary who was authorized to function, he is still functioning, my lord.
So,
So if the case goes, my lord, then he may be affected.
who? The secretary? No, so why should this court exercise the writ jurisdiction on account of the respondent or the secretary if the petitioner is not affected? You are asking for a writ of certiorari. Writ of certiorari, the basic principle of a writ of certiorari is not that it should be given on the mayor asking now. Yes, at that point of time, when you filed the writ petition, it was right and it should have been dated that point of time. But does it have any impact now? When you are no longer a member of the board of directors, you are no longer a chairman, what means?
Not a thing, no doubt. But my point is, my lord, because we took up this resolution in the capacity of the director of board of directors, my lord.
Understood, but does it remain now? If you are aggrieved by any other action, it's a different aspect of the matter. Or if there is any other resolution which is wrong, because otherwise nowadays you see after the Cooperative Society of 2007 had come in, now it is being made more democratic unless earlier than the 1948 Act. So now anything can be placed before you are being a shareholder. You have a right to place it before the board. That you can very well do it, but can you maintain this reputation now?
As of that, you are only board of staff. That is survive.
The learned counsel for the petitioner submits that the challenge which was made to the orders dated 4/8/2015, 26/8/2015, and 1/9/2015 no longer survives, taking into account that in the meantime, the period, the tenure of the petitioner as the chairman of the board of directors of the cooperative society in question is over, and the petitioner at present is not also a member of the director of the board of the cooperative society. Taking into account the above, nothing survives, this court closes the instant petition as infructuous. In term order, if you need, and vacate it.
Five,
Yes, madam. What is your right? Hmm. It's a government land. Yes, madam. It's a government land.
In this company, it's from my daughter. It's not regular,
Yes, what is your instructions? Hmm? Madam, this is not a thing that the matter has come up after a long time. This matter has been coming every time. And Ms. S. Sharma, the learned advocate, is granted time to obtain instruction with regard to the status of implementation of the water supply scheme on the land under Moza Siladi Bhopa, which is situated at North Guwahati of here. Instruction be placed before this court on the next day. The learned counsel appears on behalf of the petitioner. List the matter of 2 weeks. Then,
Letters, in the fire, I had seen, she has written,
Chalo, we call the DC. No last chance business. Last chance business doesn't work with this court. This can't happen like this. Why for all these years there's nothing? It's only the only thing which is remaining out here is because he has already been dispossessed. The only question which remains now is as to whether the petitioner would be paid the compensation or not, or has been paid the compensation or not. That's all.
I try to get the instruction.
Tomorrow. We still have one more day.
Six reopening.
The instant petition has been filed by the petitioner, being aggrieved by the actions taken by the respondent authorities to dispossess the petitioner from his land measuring 4 bighas 2 katha 10 lichas covered by Lakhira's Patta number 1 of Dag number 220 of village North Guwahati under Moza Sila Sindhari Bhupa in the district of Kamrup Rural, Assam. And in the alternative have also made the prayer sought for the relief that the petitioner be paid the compensation if in the circumstance he is dispossessed from the land. This court finds it relevant to take note of. That by an order dated 4/12/2015, notice was issued. And taking into account that there is an urgent need for implementation of the water supply scheme, the status quo order which was passed earlier was vacated. However, making it clear that the case shall, that the pendency of the case shall not bar the state authorities to decide on the compensation claimed by the petitioner. Be it as it may, 7 years have passed by, as 8 years have passed by, but the respondents have been taking time on various occasions, but till date there is no instructions. This court fixes the matter again on 8th of November 2023. It is made clear that if the instructions are not received as in respect to the instant matter, this court would have no other, this court would have to seek the personal presence of the Deputy Commissioner, Kamrup Rural, on such date as may be fixed by this court.
6.
Yes. Huh? Against the petitioner pursuant to the impugned eviction notice. You've got a state? And what is the stand of the respondents?
Part of the land, they are occupying.
What is your right over the land? So,
The part of the land. Would have not been using that.
is it a government land? So if it is a government land, what is your right on the land?
As applied for settlement, but again, because it's also that portion is not there.
Hmm?
Process for eviction of the petitioner matter. Their action blood by letter dated 8/7/15 blood they revoked it.
Oh. The school has, the land has been allotted to the school
Yes,
and you are in occupation of that land.
yes. The land, there is
So
no,
it is an interstate dispute between the school and you. And what is the state doing?
they went to evict Malad.
How? If it is a government, if it is not a government land, how can they evict?
The authorities has also written Malad. 8/7.
What is the affidavit? Let us see. Is this a government school? But in a government land which has been allotted to a school, can resort to Rule 18 be made? Can it be made? But you have a lot of land. Why you after these 10 acres of land?
Other particular point.
So what? You have 96 bighas of land. And you are also in illegal possession of another 3 bighas of land. Then you cannot get settlement in view of the extent policy because you have more than 3 bighas of land. Then, and you are in moreover in illegal possession of another 13 bighas of land. We do one thing. Mr. Dubey, let us do one thing. I ask these authorities that if you are in possession of 10 acres of land which you want to keep it, let them allow it. I'll keep the matter pending. And in the meantime, initiate process for these 13 bighas of land where you are in illegal possession. What do you say? I think that is a better thought. Yeah, it is given. Moreover, the petitioner also possesses a total land of 13 bighas, 3 kathas covered by so and so, which is a government caste land. Then, apart from that, the petitioner has is a pattadar of 96 bighas, 90 of a land measuring 96 bighas. When are you going to vacate? Paragraph 3. Do you have a right over the land? Mr. Dubey? Do you have any other land over the land? Right? It's high time. 10 acres of land, leave it. It's a school.
Because I am not there.
Yeah, it is given. Paragraph 3. This affidavit was filed as far back as in 2021. Have you seen the affidavit? Affidavit of the government. Then what it means? You give an undertaking. Then you leave that 13 bighas, 3 kathas, 17 acres of land. And the government would not disturb you. What do you say? He's agreeable. What is there to take instruction? Would he agree there? There is no escaping with this thing, taking instructions. And you know, this court will say that instructions by get it by 12 o'clock. You know, I think this is the best thing you vacate it. 10 acres of government school land, why are you doing it? Because you see, can you get a settlement over the land? No. For what? You're going to vacate. Okay. Sure. We'll have it at 12 o'clock. 12 o'clock. 12:15. No, 12:15. No. This matter has to go. Tomorrow's sunset should be. Tomorrow's sunset, it may see out there in the division bench. Not here. He'll get the type copy, signed copy order today. I have never understood. If it was the only land you are having, it's okay. This is 10 acres of land and you are having so much of land out there. Why? Vacate that land. Unnecessary making this complications because nowadays in view of Rule 18, they can take you don't have a right of any right over that. You are not the proprietor, you are not the landholder, neither settlement holder, and have no right over the land in view of the Regulation 6. My thanks. Could we wait till 12:15? Or pass the order right and then you may concentrate in some other matters.
That's a very long entire contact.
Huh?
Not been in touch with my client for.
Not necessary, but it is clear out here. This is not a case of 10 lectures, you have other lands. Huh? You are in possession of 13 bighas of land. You are in possession, you have a patadar of another 96 bighas of land along with other patadars. Still, what remains? You cannot even, the paragraph number 3 makes it clear that you are even not entitled to settlement. If you have more than 3 bighas of land in rural areas, you cannot be a right to settlement. So obviously, at the end of the day, you have to vacate. So vacate it now before the puja, they can have a better pujas. चलो dismiss करो इसकी. The instant petition has been filed by the petitioner. Challenging the notice dated with the notice challenging the notice dated 23/6/2015 enclosed as annexure Annexure 4 to the petition. The case of the petitioner, as could be discerned from the writ petition, is that the petitioner is in possession of 10 lectures of land, which admittedly belongs to the Bilmukh ME School, which is a government school. The petitioner claims that as he is in possession of the land since decades, the petitioner should not be evicted over the land. And as such, have challenged the impugned notice dated 23/6/2015, issued under the provisions of Section 8, Rule 18 of the Assam Land and Revenue Regulations, of the settlement rules under the Assam Land and Revenue Regulations 1886. The records reveal that this court, by an order dated 7/4/2017, had issued notice, and it was further directed in the interim that the petitioner shall not be evicted from the land till the next date. The record further shows that the interim order has been extended from time to time. An affidavit in opposition has been filed by the respondent number 2, through the additional deputy commissioner Lakhimpur. In the said affidavit in opposition, it has been mentioned that Dag number 89 covers an area of 10 bighas 2 kathas in village Kathalguri, Miri, under Gohai Moja, Subhansari Revenue Circle, which is reserved in the name of Bilmukh ME School. And in the said Dag, a plot of land measuring 10 lechas is encroached by the petitioner by constructing a shop. It was further mentioned that the petitioner is not a landless person, and as per the record shows that he is one of the pattadas of a periodic patta number 30, covering an area of 96 bighas 1 katha 8 lechas in village Maji. Further to that, petitioner also possesses a total of 13 bighas 3 katha 17 lechas covered by the number 28 and 30 part of Kathalguri Miri village under Gohai Moja, Subhansuri Revenue Circle, which is also a government land. From the in view of the said affidavit was filed in the year 2021, and no reply thereupon has been filed by the petitioner. In view of the fact that the petitioner, in view of the stance so mentioned in the affidavit filed by the respondent number 2, to the effect that the petitioner is a pattada in respect to periodic patta number 30, and also possesses other government lands at measuring 13 bighas 3 katha 17 lechas. This court finds no reason to interfere with the impugned notice, taking into account that the petitioner cannot be said that he is a landless person and having no other place to go. In that view of the matter. Further to that, the petitioner also, as per the extant land policy of 2019, cannot get settlement in respect of the say 10 lechas of land, as the petitioner is the pattada of periodic patta number 30, which covers an area of 96 bighas 1 katha 8 lechas in village Maji. In that view of the matter, the instant petition is devoid of any merits for which the same stands dismissed. Interim order, if any, stands. Right? Huh? Who is on legs? Okay, let him be on legs. What are you asking for? Complete the land settlement process in favor of the petitioner against 1 bigha of land of annual patta purchased and possessed by the petitioner in 1975, if not remaining 2 kathas of land along with the roads for ingress. That is that the impugned settlement order of the government to the private respondents in terms of the impugned opinion furnished by the Swan Zoo, which is contrary to the inquiry. The learned counsel appearing on behalf of the petitioner seeks for an accommodation, lists the matter after the publications. Yes. What is your case?
Number 1 and 2 are the patta holders to someone in they are patta holders since 1990. They are being visited in the shop.
So why have you come before the court? On an apprehension. that you will be thrown out without notice. Okay. We can make it clear that you can be thrown out with a notice. Isn't it? That's your case. That is your entire case. What do you say, madam? He thinks that he fears that you will throw him out without notice. You should notice and throw him out. The instant writ petition has been filed by the petitioner. Seeking a direction upon the respondent numbers 2, 3, and 5 not to launch any eviction operation for demolition of the shop houses of the petitioner settled by Patta number 1, 11, 14, and 16 existing in Samarli market area under Muzahar police station. From a perusal of the writ petition, it transpires that the apprehension of the petitioner is that the respondent authorities would evict the petitioner without following the due process. Mrs. Yudas, appearing on behalf of the learned additional senior government advocate, as well as anybody, PNRD, anybody, did you see? Huh? Who is PNRD? Yes, and Mr. P. Hendrick, appearing on behalf of the PNRD department, submits that the PNRD is there, block the department submits that the state authorities shall follow the due process of law if any steps are taken to evict the petitions, if not already evicted. Taking into account the above, taking into account the stand of the respondents, the instant writ petition stand disposed of with a direction to the respondent authorities not to evict the petitioners without following the due process. The due process by issuing a notice and giving an opportunity of hearing. The above directions shall, however, shall not apply if the petitioner has already been evicted.
Right.
Yes. PNRD, what is your case? Huh? You want to close? Why? Oh, huh? Okay. The Learned Counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim order passed earlier. Interim order is there. Okay. Interim order now.
Then
Yes. Oh, this matter G+3. Huh?
I have no interest.
The instant it has been filed by the petitioner being agreed by the non-payment of compensation amount for the land acquired and the damage caused to soil. This code by the issued notice our till date the yes, what is your say? And you have no instructions. Have you contacted them? When? And what is your instructions? Ms. Yudas, the learned additional senior government advocate, submits that she has not received any instructions in the matter. List the matter. Then this court have duly taken note of the order dated 4/10/2023, whereby there was a direction to the respondent authorities to obtain instructions. Accordingly, this court fixes this matter again on 8th of November 2023. In the meantime, the learned counsel appearing on behalf of the respondents shall obtain the necessary instructions. Yes,
My land has been acquisition, but the content of the equity price.
then go there. Then acquired under what provision?
Under the highway.
Then why you are not going there? You should have gone under 3H4. 3H, H. You will come under 3H. Then, Hmm? no, you are agreed that compensation has been wrongly paid to the private hospital. Can this court do anything? Unless you file an application seeking that, look here, I am actually entitled. Have you done that before the DC? There no, before the Kala, na, they have a Kala or some authority is there, ADC. You have done it. And what the authority have done it? Saying what? Where is your application? 47? 44 in the matter of a petition for releasing the compensation as regards the land which have been acquired under so and so, and being the owner of the legal entitled to so and so. This has been rejected.
Yes.
Who is the first party?
I am satisfied.
And you are all along represented, the second party has not represented. Read the order at page 49.
Case bill. More than 3 of cases, notice has been served of the first party is priority. In all of the dates, along with the plan area. So the second part is absent from the ticket for the ticket. The ticket line design to under the model to the unbelievable. The purposes of this land are similarly serial.
Are you the Pattara?
Fine.
Lokeswar Dotto? What is your name?
My name is Mohan.
Huh?
I am also one of the.
Mohan Dotto, okay. As per the order of the.
Mother said land has been exempt. There is no woman there. The second part is one person, one person. From the formula and the proper singer is there information and submission of document and then we check what in the.
Yes, madam. Have you seen the National Highway Act? Kindly see 3H4. Let us read it together. What does it say?
The competent authority said that the decision of the Court of Constitutional
There's no other way. Then why did he exercise the jurisdiction and decide him by himself?
Yes, it is.
He set aside this order. Who are you?
Number 5. 9 and 3.
So as per you, what is it? Has the ADC done rightly? Tell me, you are trying to defend that order. Tell me. In view of the provision of section 384, has the response this ADC done rightly?
That's why I have seen only thing is that permit after we get to the level of the instruction.
Why instruction? What are you going to do with the instructions?
After having ordered not this matter now perfect.
So, no. You see, I am not anything. I'm only on the question of law. See the provision. In view of this provision, could the ADC have decided? Because you see 3H3, 3H3. So the competent authority will decide then. But if you see 3H4, it makes it clear. The moment there is a dispute, he has no business. Then see 3H5. So under such circumstances, the only way out is 3H4. Why did the ADC decide? So with instructions, can you improve your case? You may improve if the matter is not before this court. That is the thing. What do you say? One sense for what? Not necessary. I don't think these type of matters partner. It doesn't look nice. People will laugh that I have made the partner of the matter of this thing. Did the petitioner counsel say anything much to make this a partner? I must have spoken more. No, your right is not affected. Your right is not affected. The right has to be adjudicated by the authority. So they will issue notice, you will appear, you show whatever it is. I think only the reference should have been done. He shouldn't have decided this. No. The instant petition has been filed by the petitioner challenging the order dated 6/2/2017, whereby the respondent number respondent number 3. Now, what is the date of the order? Date of the order is 18/2 or 6. Challenging the order dated. You have not challenged this order. Yeah. The instant petition has been filed by the petitioner being aggrieved by the action of the respondent authorities in not making payment of the amount of compensation in respect to the land covered by DAG number in respect to the land measuring 1 katha 16 lectures covered by DAG number 765 of patta number 102 of village Soring Boruwati under Mora Bazar Moza within Amguri Revenue Circle in the district of Sibsagar to the petitioners and or not referring the said dispute as regards the entitlement of the compensation in respect to the said land, acquisition of the said land to the principal civil court as per the provisions of the National Highways Act 1956. From the facts narrated in the petition, it reveals that various lands were acquired under the National Highways Act 1956, including a plot of land measuring 1 katha, 16 letters covered by covered by suits. The petitioners, on coming to learn about the same, filed a petition on 18/3/2016 before the Additional Deputy Commissioner Sibsagar, seeking a direction for releasing of the compensation amount to the petitioner in connection with LA case number SVR/4 lane/5/15. Upon making the said application, the respondent upon making pursuant to the making of the said of application, the petitioner also filed an application stating inter alia that the respondents, the private respondents, had no right over the land, and as such, the amount of compensation should not be released to the private respondents herein. The respondent number 3, however, by an order dated 18/2/2017, instead of making a reference, decided the issue and held that the private respondents were entitled to the said amount in respect to the land in question. It is under such circumstances that the petitioner has approached this court by filing the instant petition. Mr. P.D. Saikia, the learned counsel appearing on behalf of the petitioner, has drawn the attention of this court to section 3H and more particularly to section 3H3 and 3H4 of the National Highways Act 1956 and submitted that when there is no dispute, the competent authority would be within its jurisdiction upon the to disburse the amount. But once there is a dispute, the competent authority loses the jurisdiction and has no other option but to refer it to the principal civil court for a decision in respect to the apportionment or entitlement of the question of the compensation. This court have duly heard the learned counsel for the respondents. Taking into account the specific submission, this court finds it relevant to quote section 3H3 and 3H4, the 3H3 and 3H4 of the National Highways Act 1956. The above section, the above provisions, above quoted provisions, clearly shows that the moment there is a dispute as regards the entitlement of the compensation or apportionment of the compensation, the competent authority cannot decide the same, and the same has to be referred to the principal civil court. Under such circumstances, it is the opinion of this court that the action taken by the order so passed on 18/2/2017 by the respondent number 3, thereby rejecting the objections filed by the petitioner, is on the face of it beyond his jurisdiction and authority. And accordingly, the said impugned order dated 18/2/2017 passed by the respondent number 3 is set aside and quashed. This court further directs the respondent number 3 is who is the competent authority as per Mrs. Yuda, the learned additional senior government advocate, to refer the matter to the principal civil court within a period of 30 days from the date of submission of the certified copy of the instant order. This court further makes it clear that the above observations and the setting aside of the order dated 18/2/2017 shall not prejudice either of the parties before the reference court. Production list is there.
State license.
Okay.
Now, 50.
Hmm.
The part of the restaurant also comply with their own order of demolition. You put against the restaurant number 5. The order you already filed in B50.
Who are you?
I am one of the co-sharer in the of the property, and with regard to the property, partnership was going on in the year 1995.
You want the demolition.
Demolition.
Why?
Because one of the NOC obtained for construction was.
Who is paying for respondent number 5? Who is paying for respondent number 5? And third appearance by filing Okalapam. Gautam Bharadwaj. You are asking the GMC to demolish. And the GMC having not demolished, you are before this court. Why should this court entertain your petition?
There is an order for the GMC themselves that the building constructed on the plot of land has been, the NOC obtained for construction of building has been obtained by being called.
So the GMC has the powers, let them do it. Why should this court interfere?
Was passed in the year 2018.
Okay.
And they are.
This is a private dispute between you and the respondent number 5. Why should this court under 226 exercise the public law remedy? Why?
Inaction of the respondent authority.
Not inaction. They have issued some notice. If they are not doing it, file a suit. Your contention is that you are a owner of the particular plot of land where he has raised some construction. Get a suit, get a demolition order. Why should this court at all decide all these things?
Against the order, we approached this honorable court once, and this honorable court dismissed his petition, saying that the NOC obtained by him was made for because the signature put in the affidavit for applying for the permission was obtained.
Because there he is challenging an order passed by them. And as such, a public law remedy can be very well invoked. But here, this is a private dispute between you and the respondent number 5. You are entangling the GMC. Why should this court exercise the 226 in this matter?
The state is not undertaking their own duty and complying their own order and for
They are not doing it, then obviously you have a, go ahead, get a direction from the civil court for demolition. Why should this court exercise 226?
this honorable court has the power to direct the respondent authorities in the state machinery to comply their own order passed twice, not once but twice.
If they pass an order, they don't want to comply, that is their lookout. But for whose end? But for whose end are they complying? They are to comply with their own order. Your end. So it is an intermingled dispute between you and the private respondent. Why should this court under 226 interfere?
Regarding the dispute between me and the private respondent, there is a civil suit pending regarding partition. And while the partition suit was pending, he apparently applied for the NOC and filed a false affidavit for the authority, filed an objection for the authority saying that our signature obtained therein was obtained by fraud because the person who died in the 1996, he put his signature in the year 2002.
So why didn't you get an injunction in that suit?
Well, there was an injunction in the suit.
And if there is a construction being made when there is an injunction, you know what are reliefs are to be taken in the suit itself. Why should this court under 226 exercise?
To that extent, it was all right, but afterwards, when the GMC came into action,
The GMC came into action because of you. Why would the GMC otherwise come into action? Yes, GMC. Why should you fall in between both of them? Huh? No, understood. Therefore, I'm asking you, why should you interfere between the fight between him and him? Petitioner and the respondent number 5. Are you not? Why? When there is a civil suit pending? And why should this court exercise the prerogative writs in this matter? As to whether it is his land or that land, whether the signatures are forged, can this court look into it when the matter is pending before the civil court? You have come to a finding. On the basis of that, he can very well get an injunction or even a mandatory injunction for demolition. Why should this court direct you to demolish? You are an authority, you know what is to be done. You may not be doing in view of the pendency of the civil court. Is it not? This is,
the nature of case pending the civil court's partition.
but then also, you have obtained an injunction and there is an injunction violation. Why should this court at all interfere, and why the civil court should not take any action? Tomorrow, the civil court may blame the GMC of doing it.
But those suits are constituted into a regular second standing for this normal court.
Fantastic. So the matter has gone even reached the second appeal stage. So obviously this court can exercise under 220, under 100, which this court will do.
Under
But why 226? Couldn't this not be circumventing the proceedings under the second appeal stage?
So being a REIT is a prerogative nature. when the authority-
Being a prerogative nature, that is the reason why should this court exercise a public law remedy in your case when it is a fight between both of you?
Because the public officers and the public authorities have failed to declare their own duties. When there is an order of demolition and order first when they are after inquiry, conducted inquiry, and the reason has been cited in the order. And the teacher wrote,
Understood why, but Mr. Bora, why haven't you taken action on your own order? Why do you need an instruction? No, maybe, but why?
Some negotiation between the brothers and
That may be one reason, or the other reason may be a civil suit,
that is what.
and the matter is pending before the High Court. And there is already an order directing the respondent tribe not to make any construction. You have the power to stop him from making any construction. Why should this court at all pass such orders? Didn't-
But at the operating their own order, but I would not have filed this litigation governing this honorable court. But when the authorities are sweeping over the matter since 7 to 8 years, it's not one, why they have filed this order in that 2015 and 2018? And there is the order to vacate also,
Who is going to pay the amount?
demolition,
Huh?
for the defaulting party.
No, he may not. So the GMC may not have the resources. Then who is going to pay?
As per understanding,
You
the
are going to pay?
person who has that default party.
That is it. He may not have the resources to pay. GMC may not like to expend their resources for that. Because it is a fight between you and him. Sending somebody for demolition is not a matter of joke. Then why will the GMC take all the pain?
Like what the heavily featured municipal area, right, which was demolition at the cost of the default party, the PI was. There are also case for when the illegal contract is raised by the private responsible for file. And there is a.
You are saying it to be illegal. They are not saying it to be illegal construction. They are saying that the NOC was fraudulently obtained. There's a difference between both. Those matters where if there is an illegal construction out there, then obviously this court can very well step into it. This is not an illegal construction. It is a construction which has been made by obtaining an NOC, and the construction is within the parameters of the bylaws and within the approved plan. And under such circumstances, the question of them demolishing or not, that is their lookout. But if it is an absolutely illegal construction, this court can very well step in, taking into account the violation of the statute. But here is a case whether the NOC has been fraudulently obtained or not. Why will this court decide?
Finding has clarified this is an unauthorized construction which is in violation of the GMP Act. When the source of the construction is the NOC of the subsequent construction will automatically become illegal.
What do you say about bylaw 18? Bylaw 18 of the building bylaw says that if it is a building which has been otherwise as per the building bylaws, it need not be demolished.
Will take a lot to pay.
Why? First you satisfy me on 226.
But 226 is being a public law remedy.
That is why. Being a public law remedy, why should we entertain a private dispute between you and the respondent number 5?
When the public officer themselves are taking the action and they themselves.
They have slept in respect to their orders. You give an undertaking, you will bear all the expenses for demolition. Isn't it, Mr. Vora? Because the respondent number 5, if he doesn't pay, so who is going to spend the money? Because the respondent number 5 in their affidavit has maintained, no, this NOC has been properly obtained. It's a different thing. This court did not interfere under 226 against that order passed by them. But that is a subject matter.
The respondent authorities, the power vested upon the respondent authorities and the administrative power given to the authorities, they have failed to discharge their own duty. And in that situation, in that case, one of the honorable court has the power under Article to step in and to direct the responsible authorities to obey their own order, because there is a power vested upon the authorities. And there is no other remedy left when the authorities themselves has found out that they are the order passed and the NOC obtained by the respondent number 5 in the Corvallis.
Can this court under 226 issue a mandamus in a particular direction that you do it in this manner? Or are you saying that this court should be the executing court against the orders passed by the respondent GMC? That you break this in this manner by issuing a mandamus? Recently, the Supreme Court has come up in the judgment in Unicorn and said that mandamus cannot be issued in this manner. It's their duty to do it. I would have understood if there is a violation of the building bylaws and they want to demolish it, and there is no dispute between two other private parties in that regard, then obviously this court would obviously have done it. But it is a dispute, private dispute between you and the respondent number 5. Why should this court exercise?
Regarding the private dispute, the parties pending before the Solomon Court, so far as the state machinery is concerned, when they themselves found that the construction itself is unauthorized.
So what? They may find it unauthorized. That might give you a lever for the purpose of getting a mandatory injunction for demolition.
But the ambit of Article 226 being vast in nature and
It being vast in nature does not mean that it has to be exercised merely on a man asking.
but when there are sufficient ground to show that the respondent, the state authorities themselves have failed to discharge their own public use.
What is their duty? They have. Are you saying that they have failed to implement their own order, and you want this court to exercise the jurisdiction, asking them to implement their own order? Why? How are you affected? Because it is at your behest they have taken this decision. Are the GMC not to take their decision on their own? Did the matter arose before the GMC on its own accord, or is it on the basis of yours?
I submitted the objection.
Then that is the reason why. If it was on their own accord, the question would have been different. They may not like to intermingle between both of you now, saying that where there is a civil suit, the matter is now pending before the High Court. Why should we touch it? Isn't that, Mr. Bora?
Others are fighting with it.
They are fighting.
At least the mandamus can be issued, directing the respondent authorities to look into the order they have passed in the 2018, at least to comply or to say that some affidavit should come from the respondent side that we are not in a position to comply. And regarding the demolition cost is concerned, whether if there is a requirement of demolition cost, then we can bear. So we can bear the expenditure for demolition. But ultimately, they have to take the responsibility and they have to execute the order. Otherwise, not being a private individual, we cannot initiate the process of demolition.
You don't need to. You take the recourse from the civil court. These are matters which are pending before the civil court. The civil court will do it. Don't you think so? You do a lot of civil matters, you know. Yeah? Because what action they have taken, what orders they have passed, are orders passed not on their own accord, orders passed at your behest. And this court could be confirming that order and thereby permitting an authority to intermingle into a private dispute between you and him, which may have set a dangerous precedent for a later on. That day there was one matter which I have disposed of. Here is a case that he moves the Gauripur Development Authority stating that you see the building is not good. The Gauripur Municipal Authority issued a letter to him. You demolish it. Then what happened? He could not. In the meantime, he applied for the permission from the Dhubri Municipal Board stating, look here, I want to build out there. In the meantime, there is also civil suit pending, where there is a direction, an injunction that these petitioners should not be evicted. Now, what he does to circumvent that order, he moves here and asks that here was carrying on a business of a sweet shop. He moves here and says that, look here, he doesn't have an FSS license. So as he doesn't have, close it. The additional deputy commissioner closes it, seals his office, and there he comes. And tomorrow when he comes out here, should I say, no, they are doing the right thing. If it was done at their own behest, if it was done there, on one hand, he is coming out there. The additional deputy commissioner says that this building is not safe. On the other hand, the petitioner has a certificate to the effect that the building has the permission to remain there for 30 years if there is no natural calamities. So should this read? We issued in this regard. Because this will be the fight between you and the response number 5. And this court doesn't want to give a certificate to the GMC for acting at your behest. They may do it. That is their lookout. You may confide upon them, ask them to do it. They may do it. But keep this court away from this, all these things.
At least the reply
The
would
GMC may be very happy. They may do it. You may move them properly. You may not have moved them properly. And the smile of Mr. Bora showed us. Why should this court exercise a 226 in respect to both of your private disputes and thereby bringing the GMC and asking the GMC to act? That is their duty. If they don't do it, you know what is to be done. There is an appellate authority. Go before a standing committee, isn't it? If you don't do, then obviously isn't there any other place where one can ventilate the grievances? Why should this court exercise or give a premium to what they have done? Not a good case.
at least a reply could come from the response authority as to why, what is stopping them from complying their own order. So the academic file by the GMC then discloses any reason for not acting upon their own order. So for this reason, one of these honorable court has the power to at least
No. What do they say in the GMC apply? What is their step? GMDA. Oh, GMDA, it has to be done by GMDA. There's a government notification to the. What is the GMC going to do? Who is appearing for the GMDA? Huh? Then, if you are appearing out there now, you have. You tell me why. And the order has been passed by whom? GMC. Who's to appeal? Who has filed the appeal? RFC?
respondent has filed an appeal.
RSA against the appellate order. Your suit was dismissed. Then the first appellate court
Separate for record the finding of the learned by,
and
it in my favor.
holding
Holding that the partition, the prayer were not really sought for the mother was allowed partitioning the property among four brothers.
four brothers. Okay, then there is a stay.
Agreed by that, they filed a regular second.
Regular second appeal admitted.
Cabinet
Stay.
stay.
How can they do? File an affidavit stating about that. It is always no. You are still there about GMA. And the details you can very well find out there in the affidavit file with response number 5. I don't know. Because when the matter is pending and when there is a stay to that, I don't think we should be intervening. Mr. S. Bora, the learned counsel appearing on behalf of the GMDA submits that an affidavit would be filed by the respondent by the said authority. And 6 for an accommodation of 4 weeks. List the matter again on 29th of November. The affidavit be filed by 21st of November.
Hello, 17 and 18.
Previously, last two occasions, they have been absenting and they are doing the benefit of the stay order for this body. This is with regard to de-recognition of environmental laboratories of the pollution board because of violation of some laws. So they have got a stay order, they're enjoying it, and they're with the body.
You file your affidavit.
Yes.
And what is your stand?
My stand is that already a decision has been taken, they have been issued with the so-called notices. They have replied it, but it was not satisfactory. In fact, provisionally, as per the terms of the license which has been given to them. So they also send a sample of the sample that has been collected to the board, so then accordingly, parallelly, it will be confirmed by the board equally. So they have been not doing it, and they replied that because of paucity of labor and many other reasons, they haven't been able to send those samples to the board. Accordingly, board not being satisfied, a decision has been taken to suspend the licenses. A decision was taken in the board, and it has been communicated. Against that, they have approached the court and has been asked that no adverse action be taken. So they are enjoying the benefit of the stay order to take. It is 2018 order. 31 till 2018, the stay order has been done.
Impugn notice
If you notice this, proposed notice is 3/7/2018.
not to take any course of action against the petitioner following the show cause notice.
Yes.
And further, the impugn notice by which shall not be given effect to. So these notices are these are only notices or are these orders?
So this is notice, already a decision was taken, paper publication has been also done, that these labs have been de-recognized. So against that, they have come across.
Are they still running?
Yes.
What labs are these?
These are the labs which takes various samples, air samples,
Huh?
water samples, but they are like outsourcing of the,
You outsource it
yes, we
to them.
outsource them. And at the same time,
And
they
you have
also-
issued a show cause that you don't want to continue with their business.
because they have been violating the terms under which they have been given the license. They also send the samples which they have.
Okay, we do one thing, we dismiss it on non-appearance.
Yes.
When the matter has been called for, both the petitions are called. The petitioners are not present. We don't dismiss it. We do one thing, we vacate the intent.
Yes, that was.
Mr. El Pulu, appearing on behalf of the Pollution Control Board of Assam, submits that the petitioners herein have been issued due notice and as well as opportunity of hearing was also given. And pursuant thereto, the impugned notices were issued. And as such, there arises, there remains, there has been no infringement of any right of the petitioners. The learned counsel further submits that by taking advantage of the said orders, taking advantage of the impugned orders, the petitioner are still continuing by taking advantage of the interim orders passed by this court, the petitioners are still continuing. This court fixes this matter again on 15th of November 2023. As the petitioners are not represented, this court is not inclined to extend the is not inclined to is not inclined to allow the continuation of the interim order passed in favor of the petitioners. Next. It is further made clear that if the petitioners are not represented on the next day, this court shall this court made this court shall dismiss the repetition for non-prosecution.
Nineteen.
Huh? Oh, Mr. Mora, have you got that judgment? That one? Those three. Fancy Bazaar and what? That, what do you call that? Vending. Vending? You got the judgment? I've asked them to give you a copy of it, if I'm not wrong. As regards the vending zones, those three matter, Mr. M.J. Bolwa and huh? It is theirs. To 8 inter petitions. The vending zones. One is by the Fancy Bazaar. Dealers. No, not that SPY. The other one where Mr. Anupam Sharma appeared. That one, Mazeline flow. Huh? Yes. You got it, no? No, this one I have not directed them to give a copy to me. But that one I asked them to give it because you need to take some action on this. Now it is better.
Now they have taken after their paper seal. They have, it was sealed at the particular level, and they still, I think it's very clean. Now they have to keep it in a identical. But NGO is in contact to.
Hmm?
NGO is in contact
Who?
by the party.
NGO. So NGO appointment of a NGO would what make it better? So some agency may have been, but an NGO. Anyway, now what has happened?
Running back. All right, what is the reason?
Infectious. The learned Mr. J. Roy appearing on behalf of the petitioners. The learned senior counsel appearing on behalf of the petitioner submits on instructions that the instant petition has become infructuous in view of the pursuant to the order dated 2/11/2018 passed by this court, whereby there was a direction given that the petitioner shall ensure that the Betkuchi fish wholesale market, including the toilets and drains within the market, are cleaned and proper hygiene is maintained. The learned counsel, senior counsel further submits that pursuant to the said interim order pursuant to the order dated 2/11/2018, the petitioner association have appointed agencies for the purpose of maintaining, keeping, for the purpose of ensuring that the Betkuchi fish wholesale market, including the toilets and drains within the market, are cleaned and proper hygiene is maintained. Taking into account the above, the instant petition. Mr. S. Bora, appearing on behalf of the GMC, also submits that as per his instruction, the Betkuchi fish wholesale market is presently kept in a clean and proper, have been maintained in a clean and proper hygiene. Maintained cleanly and with proper hygiene. Taking into hygiene, for which the GMC authorities for the present is not taking any actions. Taking into account above, the instant petition stands closed as it has become infructuous.
Immediate come from the deputy commissioner, I don't. Take them both.
Yes, the government has filed the affidavit.
Yes.
It is not on record. Government has filed affidavit.
I hope not have to be, but I was thinking to it.
Who are you?
It's Flegma Mender.
As much. Yes. Filed by whom? What does he say? I've got it. Yes, what do you say about the inquiry report?
Yes, my inquiry report is already model. The deputy commissioner has said that inquiry report is what wanted model. And the deputy commissioner, my lord, the instructor put us in the like there also. File an FIR before the police. Because we also did.
Huh? No, inquiry report is an exhibit B. Page 44. In continuation of my earlier report dated, I have the honor to submit the report in connection of Pisala so and so. From the above, it has not sells to such retailers in such quantity and at such intervals of time as may be directed by the license violated so and so. Therefore, authority may be asked to show cause. Then what happened? Who is for the Pisala GPS?
I know,
Okay, then you have been show caused.
yes, my lord, and initially I had declared for 9, 10, and 11.
Ah,
In the meantime, my lord, on the basis of this February and 11 was removed and new certificate has come in. So it is also reflected in the application.
ah,
And the application was registered against the secretary.
Hmm.
As per the teacher final of the verification, no FI was registered, but as per the application, FI is registered against the secretary.
hmm,
And the second allegation was for the removal of the GPS and for the inquiry of this report. And on the basis of inquiry 11 was removed and new certificate has come.
hmm.
Yes, the customer, secretary and certificate and certificate.
Finally, it also been noted into annexure P45, that's the order, whereby it has come to the conclusion that we had Deputy Commissioner, Licensing Authority, in exercise of powers conferred upon me under the provision of clause 51 of the Assam Publication do hereby.
So it has been near.
Yes,
You wanted that the license be suspended. It has been done.
Yeah.
So what remains? All your reliefs have been duly taken care of. Lahore. Mr. R.P. Sharma, the learned counsel appearing on behalf of the petitioner submits, learned senior counsel appearing on behalf of the petitioner submits on instructions that in view of the affidavit which have been filed by the respondent number 3, and more particularly on the inquiry report enclosed as Annex B, and the order dated 21/11/2019 passed by the Deputy Commissioner Lakhimpur enclosed as Annex C. Nothing further remains to be adjudicated in the instant petition. Taking into account the above, the instant petition.
And the
The FIR has been registered,
yes, FI is registered cases of
then
After 156.
taking into account the above, the instant petition therefore stands closed as infructuous. Huh? No, all your names, everybody, you want yours, your juniors, anybody's name, you give it to them, they will record it.
23.
Yes, what is your case? Non-consideration representation of poultry for acquisition of ownership rights of the landlord under the. Oh, then. Have you moved the Board of Revenue? Have you moved the Deputy Commissioner? Then what did the Deputy Commissioner do? No, did the Deputy Commissioner dismiss it or allow it? No steps. Yes, why no steps have been taken? The petitioner herein is aggrieved by the inaction on the part of the respondent authority in not taking steps in respect to the application filed by the petitioner seeking ownership rights under the provisions of the Assam Temporarily Settled Tenancy Act 1971 in respect of a plot of land measuring 3 bighas 6 lechas covered by DAG number 434/279 new of Patta number FS grant number 1 under Revenue Village Panikhati, Moza Beltola under dispute revenue circle. It reveals from the reports that this court had issued notice as far back as on 5/2/2021. However, till date, the respondent authorities have no instructions in the matter. Taking into account the above, list this matter again on 24th of November 2023, on which date Mr. S. Borua representing the S. Borua and Mrs. She has no business. Revenue has no business. You, Mr. S. Borua, appearing on behalf of the Deputy Commissioner, Kamrup Metro, shall obtain the necessary instructions in the matter.
24.
I am looking for some.
How did you die?
It was a 10
Huh? COVID?
10 years.
Page 10. Postmortem. Death was instantaneous as a result of a crushed injury sustained over the head. All the injuries described by antemortem caused by blunt force impact which was with railway. Oh, railway have done it. Now, whether railway will come within the ambit of the 1511?
Yes.
Huh?
Yes, sir. And similar matter also set to by.
Where? Where? No, let us see 1511.
Still public. At first 21. That's clear number two.
Where is your application?
Application at first 20 hours. 5/1/2/11/2020.
Who are you?
And
Who are you? Who are you? When did the husband die? 19.
yes, sir. Petition number 1 is the wife and 2 and 3 are the mother and father. And petition number 5 are the minor son of the.
How many people want the money?
Legal name, next of kin.
Next of kin.
Yes.
Don't allow me. 3 months.
I'm taking up.
25.
It is 1511. Do you for it was 1511. They will verify. That will Mrs. P.R. Mohanto appear police for revenue. Their submission to record the similar out also. Asif, good order. Atipa could leave for the order in. Yes, who is appearing?
I challenge the order of the damage member, madam, the Assam Board of Revenue, madam. That order was expiry order, madam. We had appeal, madam. We want that one date, madam, one of the office there informed me that it will be hardened so and so date. But that was not informed, and during the lockdown period, madam, it was expiry order, madam, passed.
Which order?
Madam, face, madam, that is 5/1/21, madam.
Huh?
5/1/21, that is 60,
Page?
67.
Yes. Hearing was on 22/12/2020.
Yes,
Are you saying that on that date COVID was there?
yes, madam. COVID was there. Full COVID period. It was starts from March 2020. 2020. Only one date, madam. Council who was engaged to be informed, madam, in this way, madam. Yes, sir, on 17/11/22, 2020 date was there, madam.
Your appeal was dismissed?
Dismissed, madam.
Very good.
Again, this time, madam, I have come there.
Huh?
We are going into the merit also, madam, you are saying. Otherwise, you have merit also.
After writing so many pages, are you saying that he has not gone into the merits?
No, madam, I want to, madam, just my side.
First of all, why did you make a submission that it is was during COVID?
Yes, madam. Because, madam,
On 22/12/2020, whether the courts were closed on account of COVID?
not close, but
Right.
revenue department, actually revenue board, madam.
So?
Council was apprised, madam, by the office where council apprised that case will be hard on.
Show me that notification.
The
It's not, that would be-
Don't make those statements unnecessary.
sorry.
Come to the merits now. Tell me, what is wrong with the order?
Because, my lord, there were not, in this case, my lord, earlier occasion also, my lord, when it was, records for, my lord, because the petitioner, my lord, notice was not served, my lord. Prior to being sent, my lord, there, my lord, ABC order is there, my lord.
When was the appeal filed? 2015. 15. And there has been only one date.
Only one date, it was, my lord.
Are you saying that there, when the Board of Revenue categorically says has been filed in the year 2015 and since then several dates have been fixed for hearing?
Yes, sir, that is mentioned here.
Huh?
That is here, my lord.
On last occasion, on 17/11/2020, a last chance was given to both the parties to give their final submission. But the learned counsel for the appellant is absent without intimation and without taking any steps.
Yes.
And what is wrong?
On 17/11, he went there, my lord.
Then,
Told my lord, that chairman has done come, it would be, it will be installed. But it was fixed on 2020, my lord.
okay, what is your case in merits?
Yes, my lord, on merit.
What case you have?
Yes, merit, my lord, on merit, what is second here, my lord, additional deputy commissioner, pass order. And you give your lordship, that is.
Mr. Counsel, you are the landlord or the tenant?
I am the my lord landlord, my lord, because my lord.
You are the landlord. Ownership rights have been given to him.
Ownership, initially ownership was along with them, my lord.
So
Subsequently,
you were the tenant.
yes, my lord. From directly, I have,
You purchased,
yes, person.
you purchased it from the
From the riot, riot.
you purchased the land from the right.
Yes, madam. In year 70, after final token was given to him, I passed it. Year 70,
Then
thereafter, madam.
you step into the shoes of the right.
Yes, madam.
Can there be a sale of a righty quotient?
But as it was in the possession also handed over to us.
Forget about the possession. Can a righty quotient be sold?
But as they were the madam, also riot is my lord.
Can a righty quotient be sold? Then
Madam,
what is wrong?
72 and 83, madam, tell me.
Maybe.
Yes,
I'm not on that. But can a righty quotient be sold?
if it is, it can be transferable.
How?
If it is, he is also gonna purchaser also gonna riot.
So me? Can a righty quotient be sold?
But they have included on anyway, I prepare it, after packet number. I'll prepare it. Otherwise,
So you have no issue with the learned Board of Revenue deciding the matter
no.
in that manner. Now you are on merits.
Yes, only way.
So I record this.
Notice not served upon me, madam. Notice not served upon me,
For what notice?
but for proceeding the right, let the right case. was
No,
filed.
first of all, you have to have your rights.
Yes, madam. You have right.
So your right will only spring if you can, a righty quotient can be sold.
In which way, madam, we are talking, madam, land, madam.
First of all, you have to be a right
Yes, madam.
to get the benefit of ownership.
Honor.
So first, you have not got the right. Do you have a right? Can you purchase the right?
On the possessory right, yeah, madam.
Possessory right is different, but a quotient right, can it be given, sold to you?
There has to be exam.
Because the moment, as far as I know, the right, if he doesn't want to keep it to himself or his family members, he has to surrender it before the deputy commissioner.
But that was not done.
Then-
But as it was from the year 70.
Okay, Mr. H. Das appearing on behalf of the petitioner seeks for an accommodation to be listed after the Puja vacations.
27.
And the pertains to non-renewal of passport.
Huh?
Non-renewal of passport.
Non-renewal of a passport. Menuka Gandhi. Where will you done that?
Here the petitioner.
Yeah.
special funds are not for an.
Where do you want to go?
I don't, we are not intending to travel abroad, but complying with the orders of the London trial court, wherein you will permitted to renew a passport and deposit it back to the custody of the London trial. If my lord comes to case number 20, this is an extra 4 matter, the repetition matter. And I got number 5. The order of the trial. Deposit back the same before the.
That case, there was some judgment. See, from Jammu and Kashmir. That was this, the earlier chief minister's daughter on the passport renewal. There were certain guidelines or something at the later. Anyway, Mr. Gugoi will take this up matter later after the vacation because this will take some time.
No, otherwise also where the file is already closed. That's because the petitioner has not submitted the documents as part of this nomination issued by the Ministry of External Affairs. So my lord may dispose of the matter with the direction to the petitioner to submit a test proceed with all the relevant documents.
Why should I direct him to file? He is at liberty to file.
Otherwise, the matter is closed 3 years back. 3 years back matter is closed. The file is closed as per the Ministry's direction.
Show me that.
Now, I think the procedure.
Page.
Page annexer, I have proceed, page 16 in terms of the running page, I have.
Yes.
The file program.
This is the order passed.
Proceed.
This is the order passed.
Proceed, which is in
Page 16.
Page 16.
There is an order passed in the court of the learned judge special court. MPs and A. Barasat.
No. In our affidavit.
Affidavit, I'm looking into it. This is the reply.
Affidavit filed by Lordship once, S.C. Vishwas. Regional Passport Officer.
Page 16. Okay.
Page.
Please refer to the passport application pending in the so and so you requested to report in person along with the desired documents found or before 1 month of the issuance of the letter. We presume that you have nothing to say and so and so. What are the desired documents?
Lordship documents as far as we have annexed Lordship,
Where?
the under page 8.
Page?
Page 8 or affidavit.
What are the documents? This is an undertaking.
Undertaking, it should be Lordship as part of next page Lordship, official memorandum Lordship, page 9 Lordship.
Issue of passports against whom criminal cases are pending before a court.
As per DSR
The
570
issue to
Lordship.
evidence shall be issued in one any quantity issued this court. What are the documents required?
But petitioner has not submitted that undertaking.
You want only the undertaking?
Undertaking.
That's all?
So,
Nothing more than
Lordship,
that.
he may file a first petition Lordship, undertaking, first application Lordship, and undertaking along with Lordship, the after filing the undertaking, the PVR also required, that will done Lordship after filing the first. Police verification report will done Lordship after filing the first representation. As application for renewal of passport. So my lord may grant him a liberty to file a first, as because the file is already closed. Therefore, we have no objection. By fulfilling the Lordship, the guidelines, official memorandum Lordship 10 October 2019.
Are you saying it is only the undertaking he has to do it?
Undertaking.
Nothing more.
Undertaking is required, then Lordship police verification is also required Lordship.
The police verification will be subsequent to
Subsequent to the
your his filing.
his filing.
That you will do it.
Lordship
That will be done as per your
As per
own
our
system.
procedure.
The procedure. That you will do it.
Lordship.
But it is only the undertaking.
Undertaking. Undertaking is-
So what you have submitted just now, that he has not submitted the documents, you are only referring to the undertaking.
Yes, undertaking. Yes, not referring the undertaking. Not. Even our affidavit also, my lord.
You
may
do one
find-
thing, then we close this at the submission of the learned counsel for the petitioner. saying that in view of the closing of the, he may be given the liberty to file
Lordship,
application and along with submit all this document and you shall consider as per your office memorandum.
Lordship, Lordship,
That is the only thing.
Lordship.
Basically, a reputation matter. Filed within the premises that the litigation was being
Withheld.
withheld on the basis of an adverse policy. So far as our application before the concerned authority matter, we have mentioned the pendency of a case which is pending before the next trial court and West Bengal, or for another matter. So my lord, will file a fresh undertaking and as per the office memorandum, my lord, passed by the Ministry of External Affairs, in that comes an observation when we made, my lord, so that complying with the direction which are given.
Where?
This is when our entity lordship based and lordship.
No, that I've seen it. Wow. If an undertaking is incomplete or miscellaneous. So he will go as per the new office memorandum.
Yes, lordship, lordship. As per the office memorandum, we will file lordship.
No. You are to dispose of as per the office memorandum.
Lordship, lordship.
Your case is still pending.
No, lordship, it is a close. But criminal case is pending.
Criminal case is still pending.
So criminal case is pending. So under such circumstances, you have to give that undertaking.
Lordship, lordship.
And we have to return the party because it is by 3 years, because the order was passed way back in 2000.
Let me dictate the order. Listen.
Yes,
what
lordship, lordship.
The learned counsel appearing on behalf of the petitioner, drawing the reference to Annexure R5 of the affidavit filed by the respondent number 3, submits that as the file pertaining to the renewal application for passport, the file pertaining to the renewal application of the petitioner, the renewal application of the passport by the petitioner have been closed on the ground that the petitioner at that relevant point of time did not furnish the undertaking. The petitioner would not like the petitioner. The petitioner would the petitioner be given the liberty by this court the petitioner be given the liberty to withdraw the instant petition with a be given the leave to withdraw the instant petition with a liberty to approach the respondent authorities seeking renewal of his passport by submitting the undertaking, and a direction be issued to the respondent authorities to consider the application of renewal of the petitioner if so submitted as per the office memorandum dated 10/10/2019. Mr. K. Gogoi, appearing on behalf of the central government, submits that the file pertaining to the renewal application of the petitioner have already been closed as far back as in the year 2021. On the ground that the petitioner did not submit the undertaking, which is in the format as stipulated in Annexure R1 to the affidavit filed by the respondent number 3. He further submitted that if the petitioner files a fresh application seeking renewal by submitting the undertaking, the respondent authorities shall duly consider the same in terms with the office memorandum dated 10/10/2019. Taking into account the above submissions, the instant petition stands disposed of. Granting the liberty to the petitioner to file a fresh application seeking renewal of his passport. The petitioner shall and passport along with the undertaking in the format as given in Annexure R1 to the affidavit filed by respondent number 3. This court further directs that in the event the petitioner submits the said application, the respondent authorities and more particularly the regional passport officer, Guwahati, shall duly consider the same in terms with the office memorandum dated 10/10/2019. With the above, the instant petition stands.
You might also have a copy of this order, copy of the order along with the application.
The petitioner shall also be at liberty to submit. No, application has to be done in this manner. You are to do the application as per this.
Application, they have the online portal, they have to submit.
That is the problem.
First,
And the petitioner shall also be at liberty to submit the certified copy of this. A copy of the registry is directed to serve a copy of the order to Mr. K. Gogoi, the learned counsel, who shall forward the same to the respondent number 3. For you. I think that will be better. The online format you cannot. Yes. Hmm. Respondent number 2 affidavit has come.
Yes.
Then? Then
Is the case lawsuit. This one are the elected group member.
other
Elected group member, working for the government. 620 signatories along with the petition completed application to the authority for given sum of fees. For to give the benefit to the board laborer, they are the local holder. During that time, the COVID situation was, they are that now making.
Mr. F.E. Bormuya will take up this matter of publication. This is the matter after taking into account the pleadings. You are not filing a reply?
They have filed the legitimate lawsuit.
No, are you filing a reply?
As per record lawsuit, what
Mr.
the lawsuit
Are you going to file a reply?
lawsuit.
Mr. The learned counsel for the petitioner seeks for an accommodation for filing a reply to the affidavit filed by the respondent number 7 and 2. Respondent number 2 and 7. This is the matter again on 29th of November 2023, 1st of December 2023. In the meantime, the respondent, the petitioner will be at liberty to file their reply by 29th of November.
31.
Okay, that's it. Yes, no records. Mrs. Esburwa appearing on behalf of the respondents seeks for an accommodation to produce the records on such date as may be fixed by this court. The learned counsel further submits that she would like to also obtain the necessary instructions. Something is wrong, something has been closed down,
License matter has been cancelled.
cancelled. Mr. Ashram, appearing on behalf of the petitioner, submits that the license of the petitioner has been cancelled and for which the petitioner has been deprived of his livelihood. Livelihood. And as such expresses urgency in the matter. Taking into account the above, list this matter again on well, I'm not there from 4th of December, I'm not there. We'll have it up on 4th of December. On 4th of December 2023. On which date Ms. S. Woolworth shall obtain the necessary instruction as well as also obtain the reports.
Happy to cite us.
Yes. Ah. No instructions? Yes. How will they obtain instructions when you move the matter after 23 years?
They have made several representations to the.
No, representations. You keep on giving representations. Better. You can come up like this. One fine day. Oh, let us wake up one fine day and move the High Court. High Court is just waiting in there. There is no cases nowadays. So let's file a repetition of a land acquisition matter which stood settled in 1976. Make payment of compensation for the acquired land of so and so, acquired in the Iman along with their house, Sirat and the Can't be like this. When did you file? No, when did you move the authorities first? Show me that the land of yours were acquired. What is your name? Huh? M. Chandra Kumar. Oh, yeah, Dhiren Kumar. You were issued notice. You are the illegal possessor of the land after receiving notice. This no leave the acquired land. Otherwise, we shall proceed. Then, the government has acquired the land. The land was acquired for several years. Was the land belonging to you? Show me that. Where is your document? That you are the owner of the land. No documents. 16? 60? 16. कैसा पता? 16 is a कैसा पता? कैसा पता of when? When was this issued? Huh? कैसा पता when? If this land was acquired 414, dark number 36. Oh, dark number, 414. Bimala Kumar, wife of so and so. Area is 1.11 R. In the year 19, according to 440 number corridor, the Dalil inherited on so and so above Patta number has been repeated in the name of Bimala Kumar, Dhiren Chandra Kumar, and so and so. Hello. Yes, madam, you obtain your instructions. What is this? Why no instructions? Hmm? First, you only, other things will look into. First, obtain the instruction as regards the authenticity of these documents. Annexure 1 to 1. And only as regards annexure. As to whether in respect to this particular dark, there was any semblance of any right of these people. Because what this court sees, that in respect to the said land, there was a direction or notice issued to them to be evicted. Why would that notice be issued if they had the right? You just place the matter immediately after the applications. In the meantime, Mrs. Asbur shall obtain the necessary instructions. None.
33.
Yes, acquisition. You are challenging the rate.
No, we are one the competitor to pay.
You have not received the compensation. You have not received the compensation. What have you received?
Nothing yet. But now.
Release? No. The fair and full compensation as may be permissible under law. Have they received the compensation?
No,
Why?
this is for the under the petroleum and minerals pipeline and acquisition. Land is acquired and only the right of use is there.
I know that, but then also you have to pay.
We have calculated compensation, my lord. Lastly, speaking order is there, my lord. There is dispute with regard to his brother who's in possession of the property. But my lord, we said that landholder will get the property. They have to submit their indemnity bond and all that. But report that they have come to this court. And next thing is that it is a district judge, my lord, in case of compensation, they have to approve the district judge of the jurisdiction where the property.
Okay, we'll have it after vacation. Let's have it on 8th of November. Hmm? Let the matter be listed again on 8th of November. In the meantime, the petitioner shall be at liberty to file the necessary applications before the authorities concerned for release of the claim. Such application, if so filed by the petitioner, shall be without prejudice to their rights to seek enhancement of the claim.
And on submission of documents,
File application along with necessary documents
but let it be on 10 by God.
on 10th. Yes. Oh, we'll take it. We'll have it after vacation. Why should we break it? I know that 9 feet.
Yes.
And the remaining feet, you wanted to take instructions in the matter.
Yes.
Well.
My questions are, my lord, because none of the person who has present on behalf of the petitioner, lord, their signature was not taken on the report, my lord. And the person whose signature appears, lord, he went to the office, central office, after 3 days that signature has been. Lord, I'll bring on about.
You file an affidavit.
Yes, sir.
Mr. R. Dubey, the counsel appearing on behalf of the petitioner submits that contradicts the report submitted by the respondent authorities to the effect that the petitioners is in occupation of any land of NHAI. He submits that he would like to file an affidavit in that regard. List the matter again on 15th of November 2023. In the meantime, the said affidavit will be filed.
And about 34 for.
Yes,
I got an order to comply with money.
order complied with.
Complied with, but nothing is given to us. It's money is in their pocket. The money should be given, they may monitor our works.
What?
They have sanctioned a sum of rupees 6, earlier there are more amount, but later on they have deducted something, lastly 6,71,426 has been sanctioned. Now, only sanction in paper, technically we have got nothing. So we could not start the work. So our prayer is that let the amount be handed over to us, we will start the work and they will monitor the work. We have no problem.
His court is of the view that petitioner representation have to be considered and a decision taken on the, if the funds of the have been utilized elsewhere, the same should be reflected by the authorities while deciding. If the funds are lying with the debtor, the respondents should consider implementing the schemes at the earliest. Are directed to examine the money and within the period of, no, the money will be with them.
Yes.
They will only issue subject to the work being done.
The work has been not vested to them. The work has not been vested to them. That contract has not been.
Given to them. It is lying with you. You are going to vest it.
No.
Okay, we'll have it after vacation. Mr. The name appearing on behalf of 1 and 2 submits that the order has been complied with, which Mr. M.U. Mahmood strongly disagrees, refutes. List the matter again on 10th of November 2023, on which date? For further consideration.
Second number 1.
I know that is that too.
কি আৰু বেছি কৰিছে মই বহুতে ঘূৰি আছে মই চিনি পাওঁ না মানুহ বহুতে ঘূৰি আছে
ফিক্স কেস কিন্তু আপোনাৰ বাৰে কৈ আছো আপুনি ফিক্স থাকিলে কেছটা আগতে মাৰিব পুৰণা ডিছপ'জেল কেছবিলাক মাৰি থাকে এইবিলাক নামাৰে সেইবিলাক আগতে মাৰিব অকণমান চমুৰাইটো নহয় চমুৰাইটো নহয় আপুনি এইটো কি বুজি এই কেছটো ৰাখিলে আৰ্জেণ্ট কেছটো চব চমুৰাইটো নকৰে ন হ'ব অফিচ বিলাক কৰিলে পিছত দিগদাৰী হ'ব চব কিছু মৰিম মানে মানুহ মাৰিব ইয়াত আমাৰ কোৰ্টৰ যোনবিলাক এপ লাগি থাকে এইখিনিতে পাব হা মানে ফ্ৰিকুৱেণ্টলি ইউজ হৈ থাকে বোলে বাকী আৰু ঠিক আছে নাজানো কি আছে কেতিয়াবা সময় এটা মই আমাৰ বহুত ধুনীয়া আছে হয় না বাৰী এই 2 মিনিট চাৰে গোটেইকেইটা মাতি দিব কৈছে 2 মিনিট ৰখিব নহয় 2 মিনিট যেতিয়া ৰখিব কঠিন কেতিয়াবা জাহাজতকৈ কি ডাঙৰ ওলাইছে 2 মিনিট ৰখিব নোৱাৰে ঘণ্টা চলাই থাকিব লাগিব হয় নাই আমি বিলাকে চাকৰি কৰিছো হয় না লাইটটো বন্ধ কৰিছে নে কৰিছে
When? You are there in this matter? You are there in this matter?
Yes, and the filing of all of this.
Pursuant to the order passed by this court on 16/10/2023, the Deputy Commissioner, Kamrup Metro, had filed an affidavit stating inter alia that the land measuring 8 bighas, 0 kata, 18 lectures, covered by DAG number 770, 772, 727, and 769 of KP Patta number 32 and 284 of village Zaporigo under Beltola Moza would be acquired as per the provisions of the Assam Land Requisition and Acquisition Act 1964. It is also mentioned that the land would be acquired, that though the land would be acquired as per the provisions of the Assam Land Requisition and Acquisition Act 1964, but the compensation would be determined in accordance with section 26 to 30 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Be that as it may, there is no mention as to where, as to what proposals have been initiated in that regard in the affidavit. Accordingly, this court fixes this matter again on 2024 list. 10th of January 2023 to 2024. On such date, both the Deputy Commissioner, Kamrup Metro, as well as the Deputy Commissioner, Kamrup Metro, shall apprise this court on the next date as to what had progressed in the meantime as regards the acquisition proposals. This court further directs that in the meantime, the amount of rupees 9,91,374.82, which have been deposited by the Director of Medical Education Assam, be disbursed to the persons entitled to, including the petitioners, which is the higher charges, which is the requisition rent for the period from 1/5/2000 to 31/10/2021.
It's only rent.
Huh?
This amount is only rent.
That is what I'm saying. This is the requisition charges.
Negotiations are rent.
Be paid, I've said, be paid within this period. Let's see. Huh? Otherwise, I could have disposed it off, but if I dispose it off, they will again slip.
So we will find that. I have to. ওদের ফাইল আছে লোয়া করে আর লিস্টার আছে না লিস্ট
না এটা এবার আমি টেলিফোন ওলা লেলাম কালিলো বন্ধ হোক কোন এটা ডিপি করে লিখছেন না মানে এটা কথা না মানো এখন জানেন আগে দেখে বলবো তো রাস্তা কমপ্লিট দিয়ে দিই আপনারা হ্যাঁ না রাস্তা কমপ্লিট দিয়ে দিই বাইরে মিস্টেক করা কানেকশন দিয়ে বললেন তো তোমার কি হবে আমি ইনশাআল্লাহ তা বলে খালি তোমার ঘুম হ্যাঁ দিয়ে দিতে
Yes. Esto es la prueba, ¿no? Esto no es la prueba.